Furthermore, the government has not demonstrated that it has introduced a necessary legal regime to create the possibility for someone in the applicant's position to lodge property claims with the courts of Azerbaijan. The applicant's second principal submission on domestic remedies is that the rule of exhaustion does not apply in cases where there is an administrative practice amounting to repetition of acts incompatible with the Convention and official tolerance by the state authorities, which makes any attempt to bring proceedings futile. In summary, it recalled that the original forced expulsion of Sargsyan family and other ethnic Armenian families were carried out by Azerbaijani armed forces. It is clear from the statements made by the international bodies over the years that there is an absence of any political will within the respondent government to ensure the safety of the property of ethnic Armenians, as the international community has been required to censor the continuing hostile anti-Armenian rhetoric of Azerbaijani political leaders. We submit that, that there is a strong evidence of the administrative practice, which means that the requirement to exhaust domestic remedies is inapplicable. The government has failed to produce any information about the appropriate measures it has taken to reduce the general negative climate against Armenians in Azerbaijan after ratifying the Convention in 2002. In 2006 report, the European Commission Against Racism and Intolerance stated that judicial proceedings opened by Armenians trying to secure their rights are said to systematically fail due to the general negative climate against Armenians. Any recourse to domestic proceedings in Azerbaijan would have had no prospect of success given the existing discriminatory practice towards Armenians in Azerbaijan. For these reasons, we say that there are no domestic remedies that are available, effective and sufficient, and that the applicant's right to an effective remedy under Article 13 has been violated. Mr. President, that concludes my submissions, and I am now going to hand over to Mr. Grikoyan to continue.
Mr. President, I shall make submissions on applicants' complaint under Article 14, following by brief submissions on their claim under Article 41. The applicants have consistently maintained that they have been the victims of the discriminatory treatment on the basis of their Armenian ethnic origin in violation of Article 14, taken together with Article 1 of Protocol 1, Article 8. As a result of discrimination manifested against the applicants on the ground of their Armenian ethnic origin, they have been firstly restricted from returning to their home and to their relatives' graves since 15 April 2002, and secondly, they have never been provided with a remedy to redress their situation, and thirdly, they have not been given any material redress for their losses. In this case, the clear difference in treatment is a fundamental aspect of it. The Sargsyan family, as ethnic Armenians, have been and still are treated differently as compared to non-ethnic Armenians within the jurisdiction of the government, who face the same fate as them, who lost their property, had to leave their homes as a result of the conflict. The evidence before the court, including the reports of international organizations such as UNHCR, the Third Parliamentary Assembly, Commissioner for Human Rights, and European Commission Against Racism and Intolerance, establishes that the convention violations suffered by the applicant are the result of the government's discriminatory policies and practice. The difference in treatment has primarily been manifested in the expulsion of a very large number of ethnic Armenians from their homes on the territory under the control of the government since early 1990s. And the inability of those Armenians to return to their homes or otherwise obtain redress. Figures published by ECRI show that about 270,000 ethnic Armenians had left Azerbaijani-controlled territories by 1999 as a result of the conflict. There has not been a single example of an ethnic Armenian returning since, or being provided with compensation or alternative means of redress. The reports of international organizations such as Commissioner for Human Rights, ECRI, and UNHCR show that since 2002, displaced persons living on the territory controlled by Azerbaijan have benefited from governmental assistance of various forms, including housing and other essential services. For example, in 2007, more than 500,000 IDPs received different forms of government assistance. Well, these steps taken by the government are highly laudable, but our point is that this contrasts with zero provision with someone in Mr. Sargsyan's position, an ethnic Armenian who's been a victim of the same conflict. As to the question whether the government can provide any objective and reasonable justification for such a difference in treatment, whether it pursued a legitimate aim, and whether the means employed were proportionate to that aim, the answer most emphatically is no. No justification has ever been provided. And we submit that there is no evidence whatsoever to establish that the government has taken any measure to combat the ethnic discrimination and racism, which is evident in this case. It has clearly failed to comply with its positive obligations under Article 14. Mr. President, I now turn briefly to the applicant's just satisfaction claim under Article 41. The principal aspect of their claim is that, first and foremost, the applicants have sought the restitution of their property, the right to return to the village of Gulistan, and to have access to the control, use, and enjoyment of their home and property, as well as access to the graves of their relatives. The applicants also seek compensation for their losses, as set out in our written submissions. We note that it is quite possible for this court to order restitution and compensation failing restitution, as the court did, for example, in Brumarescu against Romania or in Sargsyan against Georgia cases. Mr. President, concluding our submissions, we would refer also to court's practice under Article 46 of the Convention, to refer to the general measures in cases where there are widespread or systemic practices which are incompatible with the Convention. For example, in Ananyev against Russia, in applying Article 46, the court took great pains to assess what the causes were of the very poor conditions of remand centers, and also what general measures were required to address them. We say that the circumstances of this case would also justify application of Article 46. Although it would be a matter for the court as to what specific general measures to stipulate, we recall that in Senides Arestis against Turkey, the court required the government to introduce a remedy which secured genuinely effective redress for the Convention violations identified. Mr. President, that concludes our submissions on behalf of the applicants. Thank you.
Thank you very much. I call Professor Shaw.
Mr. President, members of the court, it is an honour to be before you again. I will deal with the Article 1 jurisdictional issue and will make the following points. First, that the normal jurisdictional competence of the territorial state may be displaced exceptionally. Second, this may happen as a matter of fact, not only with regard to areas under the occupation of other parties, but also with regard to areas, small areas rendered inaccessible by circumstances. Thirdly, that the distinguishing feature of this case is that the site of the property claimed is on the line of contact, the ceasefire line, and thus possessed of special features. Fourthly, that any positive obligations that Azerbaijan may be deemed to hold in such circumstances under Article 1 are being respected. This is not a case like Shirogov in Armenia, which raises fundamental questions as to the jurisdiction and responsibility of the respondent state, which seeks to evade responsibility by the subterfuge of a subordinate local administration. This case is concerned with the margins, with the periphery, both in legal and factual terms. This also is not Moldova. We have here hundreds of thousands of refugees and IDPs from both Azerbaijan and Armenia, not a few dozens. This is also not a situation of an Armenian refugee from Baku, an area under Azerbaijan effective control far away from the ceasefire line, a militarily volatile line.
Professor Shaw, the members of your team might come closer to the court if they want to show points on the map. It's quite a distance for us to... Not too close, because otherwise my colleagues on the left side will not be able to see it, but maybe a little bit more in the middle. So, if that is convenient for you, Professor
Thank
Shaw.
you very much,
Yes.
Mr. President.
Yes.
I'm obliged. We need to get a sense of the area. Our July 2012 topographical map, I can't say which one it is. I think it's the... Is it that one? Yeah, the one on my extreme right. And figure 12 of the AAAS report commissioned by the court shows clearly that there are no Azerbaijani forces in the village of Gulistan, while Armenian forces in the slopes opposite, as they are in the woods, are not shown, as they are impervious to satellite observation. The village of Gulistan is one side of a mountainside sloping deeply down to the river. On the other side of the river, according to the material presented by the other side on the 18th of October 2013, lie the Armenian forces on a steeply rising slope. This is also shown by videos which both sides have shown to the court. Thank you very much. The clear consequence of this on Armenia's own documentation is that Gulistan is fully exposed to fire from the military positions of the Armenian forces, who are situated at the very least along the rising slope of the river. I do not go into the question as to whether these are NKR, so-called Republic of Nagorno-Karabakh forces, or NKR forces under Republic of Armenia command. We've provided plenty of evidence on this in the Shiragav case. The following facts appear clearly from the AAAS.
Professor Shaw, excuse me of interrupting you. I just want to ask the applicants and the third-party government if they didn't have any objection that those maps were shown now, and if they are... they are in the file also, but I mean...
We don't have objections. We would like to have an opportunity to see them following the hearing and perhaps comment on them, because we couldn't physically see
Yes.
what those maps were
Yes.
today.
Yes. Please continue, Professor Shaw.
The following facts appear clearly from the AAAS report commissioned by the court. First, Gulistan lies fully and clearly, like all of the surrounding territory, within the internationally recognised sovereign territory of Azerbaijan. Secondly, the area under immediate concern is very mountainous. Thirdly, the area has been the object of sustained military activity. Report notes, and I quote, "Throughout the period of analysis, 2022 to 2012, evidence of military activity was apparent across much of the region surrounding the village of Gulistan. Increases in all categories of military observations were noted in the period from 2005 to 2009 and in the period 2009 to 2012. Fourthly, as the report puts it, their analysis revealed the near total destruction of the village of Gulistan by 2005. It is clear that the area is an active military one and thus dangerous to civilians. This is admitted by the other side. For example, the commander of the military unit of the NKR Defence Army, Mr. Hamlet Savoyan, declared in his evidence